Alright, so it looks like we got some breaking news coming out of Florida. It appears that a judge has partially blocked a Florida law, which has been dubbed by critics as the quote, "Don't Say Gay" bill. It has been partially blocked. Now, this is a bill that would actually bar schools as well as higher education schools like community colleges, as well as private businesses from actually doing certain trainings that include things like being against racism and things of that nature. So let's check out what exactly went down. I'll explain this to you here. The article says, Judge blocks DeSantis' Stop Woke Act, says Florida feels like a First Amendment upside down. A federal judge on Thursday blocked a Florida law restricting how workplaces and schools can discuss race during required training or instruction championed by Florida Governor Ron DeSantis. U.S. District Court for the Northern District of Florida Chief Judge Mark Walker issued a preliminary injunction blocking the law known as the, quote, Stop Woke Act, saying it violates free speech protections under the First Amendment and that it violates the 14th Amendment's due process clause for being impermissibly vague. So I'm not sure if it is substantive due process or if it's just, regular due process, procedural due process. Quote, recently Florida has seemed like a First Amendment upside down, Walker wrote in the ruling, comparing the law to the fictional, quote, Upside Down in the Netflix series Stranger Things. I don't know about anything about that. I don't know if any of you guys know. I've never watched Stranger Things. It says, normally the First Amendment bars the state from burdening speech, while private actors may burden speech freely, the Obama-appointed judge continued. But in Florida, the First Amendment apparently bars private actors from burdening speech, while the state may burden speech freely. The law prevents workplaces from requiring employees to attend any activity that violates any of 8 concepts, like instilling that someone bears personal responsibility for historic wrongdoings because of their race, color, sex, or national origin. DeSantis and other Republicans promoted the new legislation as fighting back against liberals seeking to make white people feel guilty in diversity and inclusive efforts. In Florida, we will not let the far-left woke agenda take over our schools and workplaces, DeSantis said during a signing ceremony in April. There is no place for indoctrination or discrimination in Florida. In the ruling, Walker argued the law implemented viewpoint-based regulation on speech, noting that a nonprofit could not hold a required meeting in which it endorses the concept of white privilege, while another nonprofit was free to hold required meetings criticizing the concept. Quote, if Florida truly believes we live in a post-racial society, then let it make its case, Walker ruled, but it cannot win the argument by muzzling its opponents. And so this is a very interesting situation. This is about the Don't Say Gay bill. Basically what's going on here, this is a very, very fascinating statute. First of all, it's very important for you guys to know what a statute is. A statute is a law that's passed by a legislature as opposed to common law, which is laws deemed by courts. So, for example, Roe versus Wade, Brown v. Board of Education, those are examples of common law, or as it's also called case law. There's also executive law, which are executive orders. These are all different sources of laws. So this is a statute that has been passed that not only is going to prevent public schools from doing these, from talking about these concepts, it's also going to bar private businesses, private enterprise, and upper level schooling like colleges from doing it too, which is crazy. And so you guys know, like, professors and stuff like that have a lot of freedom, which is why, like, for example, like, I've gone to community college, and the classes that I've taken there are so much more informative than high school courses, even for something like biology, because parental control isn't there, and there's more freedom to actually teach real stuff. And so you actually learn the truth about evolution, for example. You learn about an actual evolutionary chart that debunks, the bullshit, why do apes still live or whatever. You learn so much stuff in a real biology class as you do compared to like a high school one. And so this is threatening that freedom of being able to determine that. But this is just straight fascism. I mean, it's literally the state government trying to tell private businesses that they can't be anti-racist. That's essentially that they can't give anti-racist trainings to their employees. So, again, a lot of fascism coming from DeSantis is like a wannabe, like, fascist, like Mussolini, obviously. To me, is definitely what it seems like. But pretty much what this is going to do, I don't know if you guys know this, but the First Amendment of the United States doesn't actually apply to private businesses. And so private businesses are not subject to free speech regulations. The first 10 amendments are called the Bill of Rights. They were passed at essentially the same time, if not the exact same time. And they were a compromise between the Federalists who favored the Constitution as opposed to a Confederacy, and the Anti-Federalists who preferred the Confederacy over the Constitution that ended up getting passed. It was a compromise. Those 10 amendments are supposed to be checks on the federal government that the Anti-Federalists demanded in order to pass the Constitution in the first place. So the First Amendment doesn't apply to private businesses. Private businesses can do whatever they want with speech. Now, what the First Amendment exactly protects against is this law, this statute itself. The First Amendment prevents the government from, stopping speech and having a chilling effect on speech and impacting free speech. So this is just straight up illegal. Now, what I'm really curious about is when it comes to they're talking about like the schools, the public schools. I'm really curious as to how that's going to play out in the courts, because whether or not that's legal, that shouldn't be legal either. And I mean, if anything, public schools should be held to an even higher account of free speech requirements than private businesses are. Now, I'm not an attorney, so I don't know for sure. Like, I'm not an expert on this. But I would imagine that has to also be struck down to prevent public school teachers and public schools from freedom of speech. It seems like it's super, super illegal and unconstitutional. Constitutional law is the supreme law of the land, obviously. So it seems illegal to me. Now, another thing that you guys should know, like I've done some reading on constitutional law, and so this is what I have learned, and I want to explain this to you guys. What if I were to tell you that actually none of your constitutional rights are actually absolute? None of your constitutional rights are 100%, and any of them can be overridden, whether it be free speech or whatever. And so what the government of Florida, the state government of Florida, is going to attempt to argue is that they have a compelling interest in doing what they're doing and preventing this, speech that they're trying to stop. So here's how constitutional law works. Anytime someone challenges a statute or an executive order, what they end up doing is the judges apply a test, one of these three tests, to whatever statute or law there is that they're looking at here, and then they do a balance test based on whatever test they choose, and they go through the test and see whether it fails or passes. So the first one here is a rational basis test. Now, it's a test that says the plaintiff must prove that the law is not rationally related to a legitimate government interest. The plaintiff usually loses. This applies to everything else, including poverty, wealth, age, education, everything else. So a rational basis test pretty much means that the government wins like 99% of the time. So in a rational basis test, if you are challenging the Floridian law that just passed the Don't Say Gay bill, all the government has to do is they just have to give a rational basis test. They just have to give a rational basis for the reason why they passed the statute in the first place. So they could say, oh, this is to protect white people, or, I don't know, whatever they could say. They could just say anything, right? The government wins 99% of the time. Then you have intermediate scrutiny. The test says the government must prove the classification is substantially related to an important government interest. That substantially related to an important government interest is something that is a very important, terminology. It says this applies to gender and illegitimacy. It applies a lot to, I think, like gender scrutiny and some civil rights and stuff. And so in intermediate scrutiny, the burden of proof is actually on the government to prove that it has a substantially related that the law is substantially related to an important government interest. So in the rational basis test, the burden of proof is on the challenger to the government to prove that they don't have a rational basis for passing the law. In intermediate scrutiny, the government must prove that that the law is substantially related to an important government interest. I don't know who usually wins the intermediate scrutiny. I don't know if it's 50-50. I don't know. If anybody is an attorney here and knows who wins more with the intermediate scrutiny, I would definitely love to know. I'm super curious about that. Then the highest of the high is strict scrutiny. This test, the government must prove that the law is narrowly tailored, necessary to achieve a compelling interest. This applies to fundamental rights mentioned above, race, ethnicity, alienage classifications when passed by the state, besides when political function doctrine applies. So strict scrutiny is the highest level of scrutiny. It is the highest level of review for a statute. So this is an example. So the question we have to come to is, what exactly is the level of review that's going to be applied to this statute? That is ultimately the question here. What is going to be the one that applies to this? Now, considering that this has to do with free speech and specifically what appears to be political speech, it should trigger that strict scrutiny. It should trigger this strict scrutiny test. That's what it should trigger, but I'm not 100% sure. And so really, when you look at constitutional law and determining a judicial review, as it pertains to determining laws constitutional or not, what it really comes down to is which one of these tests the justice determines that it's going to be. And so this is the big debate when it comes to the Second Amendment, because justices like Ruth Bader Ginsburg and others will say that there should be a rational basis test applied to government statutes regulating gun rights, private gun ownership rights, whereas someone like Antonin Scalia or someone like that will say that there needs to be a strict scrutiny test. And so, assuming there's at least going to be an intermediate scrutiny test, right? But there should be a strict one, because this is literally political speech. I did read that non-content regulations of speech are more intermediate and maybe some rational basis, I'm not sure, but maybe like curfew regulations in terms of volume or whatever. But political speech is a viable, like fundamental U.S. like right. So that triggers strict scrutiny. Intermediate scrutiny will typically trigger, like, not segregation, but discrimination based on gender and other things. And then rational basis will just be like kind of like not very clear, rights. Maybe you're doing some kind of, anybody can claim like a 14th Amendment, removal of due process under the law. So those usually end up just being rational basis tests and they lose. But this should definitely be one where the government loses, because based on strict scrutiny, it shouldn't make it. And so what is going to be on the Floridian government's part is they're going to have to prove that they have a compelling interest. It's a necessary thing. So things like strict scrutiny that could apply to are things like, in times of war, removing like certain habeas corpus and things like that. So basically anything that is a threat to the existence of the government itself is going to outweigh like a rights violation. And so it's never an issue of, is this in violation of this amendment of the Constitution? It's more like, what is the balance between the two? Who wins? Is there a compelling interest that outweighs, the right? Or is there not? And so the Florida government's going to have to prove we have a compelling interest of preventing these things. And it's going to fail because there is no compelling interest. Strict scrutiny, the government loses like 99% of the time. So if they do apply strict scrutiny to it, then they're going to lose. I don't know what exactly they're going to apply again. I don't know how you can apply anything else, bro. It's literally political speech. That's always strict scrutiny, because political speech is a fundamental U.S. right. And so I don't know fundamental constitutional rights. So I don't know how they could apply anything else. Another interesting thing that you should know is you can't just bring a case and be like, this is just a general violate. Like, I couldn't bring up a case against the Florida government saying that this is in violation of the First Amendment. In order to win the case, you have to actually prove personal injury. So you have to prove that this actually harmed you in some way in order to have standing to bring your case in the first place. So that's also something else that's interesting to know. But hopefully you learned something about judicial review here, very important to understand. But if they do apply strict scrutiny, which I don't see how they can't, considering it's regulation of political speech, content discriminatory speech, and not content neutral speech, it should lose like 99% out of 100%. Like I said, the government almost always loses. There's very few, like maybe like sedition acts and the horrible Korematsu case and stuff like that. Times where the government basically deems that there's a compelling interest, the government interest, to override the right. So it's never just, this is in violation of the First Amendment, ergo that's it, done case. No, it's if the government has a compelling interest towards overriding your First Amendment right to free speech, then it will stand. But if not, then it won't. So, that's what we have to look at here. And the real question is, does the Florida government have a compelling interest to pass this statute? And the answer is no.